Item number 1 and 2 of today's list. Wrapped lordship is a long matter. There are two volumes of paper books. Yesterday, office gave me only one volume comprising of the judgment. Depositions I couldn't go through. Lordship may take it up any day after this week or any day, Lordship, not today.
You are appearing?
Yes.
My lord, all several times listed for hearing, my lord.
Yes, I know.
Otherwise, I have to accommodate the pain also.
There are around 100 of witnesses and so many.
No, not important. Only 5-6 witnesses are important.
129 witnesses and so many documents. That is Jhankar matter, where for 10 rupees a boy was killed. So any day, not today, I didn't go through the depositions. And Master Mahajan is also there.
Oh, you are for whom?
Item number 1, my lord. Parsing Tarang, my lord, and 9 others.
All right.
Well, only prayer ka date may be fixed, my lord.
Yeah, but date will be in the 3rd week of January. Before that will not be possible.
My lord.
Immediately after my lord review vacation, that will be 2nd week of the last, maybe beginning of the 3rd week. I take down Mr. M. Sarania and Mr. N. Mahajan are present on behalf of the appellants. Common order. Today, when these matters were called up for hearing, Ms. S. Jahan learned APP Assam submits that the 2nd volume of the paper book containing the deposition of the witnesses.
No, first volume contains deposed, second is the judgments and exhibits.
Second
Second they
volume-
gave me, first they did not.
Acha, the first volume of the paper book, which contains the deposition of the witnesses, has been furnished to her by the registry only yesterday, as a result of which she could not go through the same so as to argue the matter on such count. The learned APP has prayed for adjournment of the hearing of these appeals for 3 weeks. Mr. A.K. Hussain, learned counsel for the informant, is also present. Mr. Mahajan, she is seeking time.
My lord.
N. Mahajan only B.K. Mahajan. In view of the request made by the learned APP Assam, although urgency has been expressed in the matter by the appellant's counsel, we are left with no option but to adjourn the hearing of this case, but to suitably adjourn the hearing of this case. Of these cases. On the request of both the sides, registry to list these appeals for hearing again on 24/1/2023 as fixed items.
Obliged.
I love it.
Yeah, teacher, with regard to item number 4 and 5, my lord.
Yes.
My lord, similar since in this case also like yesterday, after we filed that appeal, some witnesses have been depositions have been recorded. So we have to look into that matter.
Item 4 and 5, Likhok, on the prayer of Mr. B. Prasad, learned counsel for the appellant, hearing of these matters stands adjourned for 3 weeks. List accordingly. You are there? So, Mr. D.K. Das, D. Das, learned senior counsel assisted by Ms. B.B. Hussain is present on behalf of the respondent and does not have any objection if the prayer is allowed. First, in view of the above, hearing of these matters stand adjourned for 3 weeks. List accordingly.
Supplemental is from item 7 to 9.
In this matter, we are the newly implemented private respondents, that is the candidates below. On last Friday, Milord, we filed our Wakalatnama. Today we are filing the affidavit, Milord. Milord, the copy will be served today itself, Milord. We have filed it already. So, Milord, Lordship, may
What
please
is
to
the-
bring that affidavit into the records.
What is this? What are
My lord,
these?
it's very unfair on my part, my lord, to mention the matter for the 3rd occasion. It's very unfair, my lord. It's an admission related matter. On the first time, about 3 weeks back, when the matter appeared, we myself said, my lord, since they're appearing for the first time, let sometimes be given to them. Court was pleased to grant them 1 week time. They did not do anything. On the second occasion, again time was given, my lord. On third occasion, again time was given. Even now, my My lord, the matter relates to admission to medical colleges in the state of Mizoram. Now, what had happened, my lord? The state of Mizoram has made a classification which was struck down by this honorable court. Same, classification has again been made, and my learned friend represents the client who are beneficiary of that, my lord, illegal classification. This is a covered case, my lord. It will hardly take 15 minutes time. I do not know, my lord, why my learned friend is renewing this prayer every time.
Lord,
My lord, we are students, we are awaiting, admission. Court has passed an order, any admission made will be subject to the outcome of the case. My lord, we have passed the NET examination, we have secured very higher marks, we are supposed to get the seat. They are the beneficiary of illegal order. Therefore, when court found that if the relief is to be given to us, then some candidates from below the persons who got, they have to be, their seat has to be disturbed. So there has to be 5 identified candidates. Now 5 identified candidates, my lord, they have been served notice, and this is what is going on for the last 3 days. And today is the 4th day.
The process is going on.
And my lord, by 20th, they're going to complete the admission process.
20th of,
This month.
January.
look,
January.
how many
So-
petitioners are there?
There are 5.
so far as we are concerned, my lord, since it's a matter from Mizoram, my lord, we could get the wakalatnama on and file it on Friday itself only. And thereafter, immediately we have prepared the affidavit within 3 days, my lord. On the last occasion when this matter came up before this honorable court in court number 1, I made a prayer that kindly accommodate me till Tuesday. I'll file it. I have already got the affidavit, and we are filing it today.
And today is
What?
Thursday. Today is Thursday. My learned friend prayed for time up to Tuesday. Today is Thursday.
I understand, since the matter from Mizoram, my lord, it's not here. If had it been from here, my lord, within Sunday, I would have prepared it and filed it on Monday.
No, that's
They
all.
are beneficiary. My government has already filed the affidavit. It's the government stand which will be material.
Who is for the government?
Yes.
The admissions are going to be made on 20th.
It's
The
already
admissions
over.
are already over, Lord. So what is happening, the last date has been given, it's 20th is the last date.
Hmm.
By that date, if any candidates, if they get a better choice, they can shift to a different college. So in that case, like there will be some vacancies. So this is going on. So till 20th, this will happen. After 20th, probably this thing will stop. So till now, Lord, see what has happened after filing of this case and all, last few days, the 3 vacancies have occurred. So 3 vacancies, we have asked them not to fill up till then. So that is the status. 3 vacancies are there. They have 5 petitioners. 3 vacancies are still there. I mean, recently those vacancies have occurred. So those seats, we have instructed them not to do anything on
And
those.
when will the course commence, classes commence?
January.
Classes January, the month of January, 20th of January.
All right. So, Mr. Chaudhary, what we propose to do is, these matters have come for motion.
No, my lord, this matter is coming up for, this is the, my lord, 4th occasion they are praying for time.
No,
That's
please,
why the matter
please,
could
please,
not
please,
progress.
please
Yes.
listen. We'll ask them to keep the 3 seats vacant. And if you succeed there, their admission will also be
Go,
subject
yes.
to outcome.
Yes.
And we'll fix the matter on 9th of January for final hearing. We'll issue notice and we'll fix it for
No.
final
The
hearing
state has already filed affidavit.
by making it clear that no adjournment on the request of the respondents will be granted on any ground whatsoever. Correct? So there are 5 cases.
No, my lord, my only concern was, in some matters, my lord, adjournment cannot be a matter of right. It's an admission related matter, my lord.
No,
In
that
a
is-
habeas corpus, in an admission, why there should be a prayer for adjournment? My lord, my learned friend wants to file an affidavit. State has already filed an affidavit. It is the state's rule. State has to defend. As a private respondent, can he defend state's rule? Why this, my lord, prayer is being renewed? This is for the 4th time. No, my lord, it sounds bad. It's none of my pleasure to start the day with all this. But my lord, there should be, people should know. We should know what to pray for and what not
That's
to
right,
pray
you're
for.
right. But then what to do? We have to operate in this system. We can have it on 6th also if you want.
I think that will be better, my lord.
6th or 9th, anything, Lord. So that's, we are ready with this.
All respondents are represented.
And my lord will record that the 3 seats they will not fill up.
Yes, yes.
So that I have stated that 3 seats are there. We have asked
Mr.
them not
K. N.
to-
Chaudhary, learned senior counsel appearing for the petitioners in the batch of writ petitions. We have also heard Mr. A. Kalita, learned Additional Advocate General Mizoram, appearing for the official respondents. Full stop. Mr. H. K. Das, learned counsel, has appeared for the private respondents. Full stop. Today, this matter pertains to claim of the writ petitioners for admission into MBBS course in the state of, in the institutions run by the state of Mizoram. Full stop. According to Mr. Chaudhary, this matter is covered under a previous judgment of this court, whereby the earlier decision of the government not to include the petitioners, not to include candidates situated in the category of the petitioners have already been struck down. Therefore, there is no contentious issue that calls for further adjudication in this matter. Full stop. Mr. Das, learned counsel for the private respondent, submits that since his clients are from Mizoram, hence he could not file the wakalatnama and the counter affidavit, and therefore some more time is required. Full stop.
I have already filed.
Huh?
I have already filed Wakalatnama on Friday.
Acha, hence he could file the wakalatnama only on last Friday, that is give the date, and therefore some time is required for filing affidavit. Mr. Chaudhary has strongly opposed such prayer by urging that the private respondents being beneficiary of the process and the matter already having been adjourned more than thrice on their prayer, no further adjournment is to be granted. Full stop. We understand from Mr. Kalita that in view of the pendency of these writ petitions, three vacant seats in the MBBS course for the current session have been reserved, awaiting the verdict of this court. Full stop. Mr. Kalita further submits that the courses in the classes in the MBBS course would commence from 20th of January, and therefore this matter involves some urgency. Full stop.
Lordship, there is one clarification, Lordship. It seems the classes have already started, Lordship. Classes have all.
20th January will be
Sure.
That
Last
was the
time 20th
instruction
January
I got this morning.
Class
Acha, 3 seats have been kept vacant. Full stop.
So there is some confusion about starting of the.
Therefore,
classes.
urgent disposal of the petitions would be called for. Full stop. Taking note of the submissions of learned counsel for both the sides, we direct the registry to list these matters again on 6/1/2023 as fixed item. It is made clear that no further adjournment in these matters on the request of learned counsel for the respondents will be entertained by this court on the next date fixed on any ground whatsoever. First of parties to be prepared accordingly. Yes. Mr. Das, will record your name.
It's okay, man.
I think he's using his good office, my lord. Hopefully something will happen.
Mr. Das, just 1 minute. If the High Court has already struck down a similar decision, as Mr. Chaudhary says,
My
these are
lord, there are
matters
two
which should
things.
not-
We have looked into it. There will be slight discrimination, what I felt. Let me be very honest to it. Open category, which has been given now at open category at 4%, they made ST and also non-miso ST. That may be a slight, I differ in every rule. Let me be very honest to it. And secondly, regarding about the class 11, 12, that also I think it's a bit of discrimination. Cannot be in respect of non-miso ST or ST, miso ST. That is a discrimination, what I felt.
Yeah, Article 16.
Yes, so far as 93% is concerned regarding about the judgment which has been passed. My lord, that I have got reservation. I want to argue on that point. If that is struck down, let us say that your lordship struck down the entire thing. Then 93% of the struck down, then it will be based on merit.
Open competition.
Yeah, open competition. Then my lord, I'll show it. It will be difficult for the chakmas to enter into it.
So
So
therefore,
we wanted,
if it is avoidable,
yes.
why not avoid it?
No, that's why my learned friend is.
No,
agreed
I
by-
think my learned friend has taken up sincerely. Hopefully something would transpire.
Let us also discuss with them, my lord. I also felt,
But if the classes have commenced, then this way, that way.
no, the classes is common,
Last
then
time
already
you
there
did
is an
this, like,
observation
20th
made by
January,
the,
probably.
by the division bench that 5 sets has been kept, my lord, I think 5 sets, subject to the outcome, they will get it, my lord.
And today 3 seats.
Only
Today,
thing
three
is,
seats
will-
have
maybe
been
will
for-
miss some classes.
No, but the MBBS course, if they miss classes, then they will be half doctors.
They
No,
will
that's
not
why
be
your
able to
lordship
make
has-
it up.
6 one classes.
Your lordship has fixed it on 6.
Those are vacation is coming in Mizoram.
Vacation is, Christmas is, let it be on 6th, my lord. If your lordship struck down entire, then it will be difficult. I'll show why it is difficult.
No, that,
But if these two category, what I found and gone through it, open category and say 11, 12, that's I think a bit discrimination is there. There
so
cannot
if,
be.
if their grievance is redressed, then we'll close the matter.
Yes.
We'll see it. I will, that's why I will have a
I
word.
think he can use his good office, my lord.
Advocate General's office is
Yes, of course.
all pervasive.
Of course.
And not to forget the additional Advocate General.
His major role, he's playing a major role.
So it's a, it will be a teamwork at the end of the day. Yes, thank you.
Brilliant.
For hearing item 10, partner.
Acha, there are 5 witnesses here.
Your lordship. My learned friend is not very well told. I don't know. Okay.
Acha, you are seeking
Your
adjournment.
Lordship, Lordship, I have prepared a case, but due to this dry cough, Lordship, I could not.
Okay, when do you want to adjourn?
Any date, Lordship, next week or. Because I prepared a note, but it's not complete. I'm
No, you tell us. If you want time, we'll give you time.
Lordship.
If you ask for it, we'll give you. Otherwise, we'll hear the matter.
Lordship,
You want time.
Lordship.
Then we'll fix it on 3rd January. 3rd January.
Lordship.
Ms. S.K. Nargis, Learned Counsel appearing for the appellant submit that although she has prepared the case, yet she is unwell today and therefore not in a position to argue the matter. Full stop. Ms. S. Jahan, Learned APP Assam is present on behalf of the state. Full stop. Taking note of the request for adjournment made by the appellant's counsel, we adjourn the hearing of this appeal. Registry to list this case again on 3/1/2023 as fixed parted matter.
Yes.
When I have prepared a note, I'll submit on that day. Okay.
For hearing item 3.
Counsel is not there.
None appears for the appellant when the matter is called up for hearing. Mrs. Jahan, Learned APP Assam is present on behalf of the state. Stop. Since the appellant's counsel is absent today, these matters, hearing of these matters stands adjourned for 2 weeks.
Item 6.
At my lord.
Yes.
My lord,
Hmm.
this is murder case. And the honorable judge of Nalbari Session Judge convicted the appellant under section 302/34. And the FIR
Hmm.
My lord, FIR is, my lord. Page 5 of paper book, my lord. The humble submission is that it has been almost 1 year since my elder sister, Arati Talukdar, married with Ekush number 1. Now she is 9 months pregnant. At around 9:30 p.m. on 12/22/2001, the aforesaid Ekush person had an argument with my elder sister of her dowry, and they in a body set her ablaze by pouring kerosene on her body. On getting information about the incident, people surrounded the Ekush, and after recovering my sister in an unconscious state, they inform her. I came to know that the Ekush number 2 had an ill intention of cohabitation with my elder sister. Now my elder sister has been admitted to Guwahati Medical College, and she is in unconscious state. Therefore, you are paid to take necessary action against the accused after carrying out investigation into the matter. This is the. Thereafter, as was one under section 302 as well as 304B of the 34. And witnesses examined 10 witnesses. A doctor to IO and informant and other 6 witnesses. Altogether, 10 witnesses, my lord. PW1 is the complainant, the brother of the deceased.
So conviction is under which section?
Under 302, my lord.
302 with 34.
Oblique 34 or by 34. Read with 34.
Where is the finding of the trial court? Let us. There is a dying declaration also.
Dying declaration is there. One dying declaration and another verbal dying declaration. Else to be dying declaration. Oral dying declaration.
All right, let us start from para 25 of the judgment.
25.
Yes.
25 from beginning, from top, no, my lord.
Para 25, page 65. Yes.
65. 65. Whether this is was unconscious.
Oh, para 25. That is not para 20.
I scrutinized the. I have scrutinized.
I have scrutinized the case record, case diary, exhibit 2 dying declaration, statement of PW1 informant, and PW4 who recorded dying declaration, and PW10 Putul Deka IO of the case. The statement of IO of PW1 informant of the case diary case clearly pointed that he met his sister after lodging Azhar at GMC, and police recorded his statement at the police station when he lost Azhar. That means police recorded his statement prior to his meeting with his deceased victim sister. Exhibit 1. Azhar was lost by the informant before meeting deceased victim and before coming to know about the incident from the mouth of the deceased. Therefore, PW1 could not make such statement in his Azhar because facts which was not in his knowledge. He did not state the same in his evidence. The cross of PW10 IO of the case pointed the recorded statement of Sampok Bora 123/1/2013 when he came to Los Azhar. PW1 made statement that his statement was recorded by police when he lost the Azhar. That means his statement recorded prior to his meeting with his deceased sister. On scrutiny of the case diary, it reveals that IO recorded statement of informant only once, that is at the time of lodging the Azhar. Therefore, when PW1 lost Azhar and when he made statement before the police, he did not hear the incident from his deceased victim sister. Therefore, he could not make the same. That is the fact of dying declaration before the police, and therefore, in my considered opinion, these facts cannot be treated as contradiction or improvement in the statement of PW1, as cited by the Learned Defense Counsel. 27. PW10, I of the case deposed 122 on 2013 at 10:35 p.m. Dr. Pallab Kolita, medical officer of Mukalma PSC, informed OC Mukalma police station over telephone that one female was brought to the hospital in half-burned condition, and they entered the said information at General Diary of Mukalma police station by GD entry number 409, dated 22/1/2013, and he along with OC Mukalma PS visited the hospital, and as they noticed the patient was in serious condition, so they request the doctor to record the dying declaration of the patient, and on prayer of Dr. Pallab Kolita, recorded the dying declaration of the patient. Thereafter, patient was referred to GMCH, and burnt patient was sent to GMCH in government ambulance by the police on the same night. Next to 28. PW4 Dr. Pallab Kolita deposed on 21/2013 while he was working as medical and health officer at Mukalma PhD. He examined Aropi Talukdar, female, aged 24 years, wife of Ranjit Talukdar, with LS burn injury, with approximately 55% with 9 months pregnancy, and he recorded her dying declaration at about 10:45 p.m. and recorded a declaration as the injured woman alleged that she has been frequently tortured by in-laws, and quarrel also took place today, and her husband has put her on fire by pouring kerosene oil over her body today at around 9 p.m. His further evidence is that injured was given first aid at Mukalma PHC and immediately referred to GMC at 11 p.m. in a serious condition in government ambulance. Exhibit 2 is the dying declaration of the victim, and Exhibit 2.1 is his signature. He stated victim was not in a position to put her signature, so her signature was not obtained, and he recorded dying declaration of deceased victim on request of the police. 29. To find out the admissibility value of Exhibit 2 dying declaration, I have scrutinized statement of PW1, PW4, Exhibit 2, dying declaration, and case diary. In the case in hand, first dying declaration is in written form. Dying declaration recorded by PW4, who is a doctor. It was he, PW4, who informed police of Mukalma PS that on burn victim brought to Mukalma PSC for treatment, and based on the information, then OC Mukalma PS and PW10 rushed to the Mukalma PSC, and finding condition of burn victim serious, they request attending doctor PW4 to record her statement. PW4 in his evidence stated that victim was in fit state of mind and was able to speak at the time, but did not retain the same in Exhibit 2. The statement of PW4 and PW10 pointed at the time of recording the declaration of deceased victim, none of her close relatives were present. As per the defense submission, the villagers and the accused persons brought the victim to the hospital. When none of the close relatives and near and dear one of the deceased victim were present at the relevant point of time while recording the declaration, the possibility of influence, inducement to victim to make the declaration is totally ruled out. 30. Exhibit 2, dying declaration is of 6 lines. The injured victim statement recorded by PW4, she has been frequently tortured by in-laws and quarrel also took place today, and her husband put her on fire by pouring kerosene over her body today at 9 p.m. The settled principle of law is that shortest the dying declaration, there is less possibility of doubt, and genuineness is more on weight. Exhibit 2 dying declaration pointed that the injured victim was given primary treatment at Mukalmoa PSC and was referred to GMCs at 9 p.m. 1/22/2013 in serious condition in government ambulance. 31. On scrutiny of the case diary, I find photograph of the burn victim available in case diary, and photograph of the burn victim pointed her right hand is under bandage. Her right palm and left palm were swelling. Injury is on the left thumb. Injury seen on the left thumb. PW4 doctor stated due to the injury, victim was not in a position to put signature, and therefore her signature was not obtained. The photo available on the case diary substantiates the statement of PW4 with regard to the serious condition of the deceased victim, for which her signature could not obtain. Taking signature on dying declaration is mere formality, and non-taking of signature does not wash away the value of the dying declaration. If same is found to be made voluntarily freely, without coercion and inducement, and in a fit state of mind. As none of the close relative of the victim was present at the time of recording her dying declaration, the possibility of coercion, inducement is totally ruled out. The police made the prayer to attending doctor to record the dying declaration of the deceased victim, noticing condition of the deceased and deceased at the time, make the statement who, according to PW4, was in a fit state of mind to speak is found to be genuine. The victim, after giving preliminary treatment, immediately sent to GMC. Dying declaration is not required to be attested by gazette officer, and writing of dying declaration in third person form not in any way sells the version of the statement made by the deceased victim. Dying declaration was recorded within 1 hour and 1.45 hours from the time of incident. Therefore, the submission of defense counsel that the sedative or painkiller has played the role in recording the dying declaration is totally devoid of any merits. 32. The statement of PW1 with regard to dying declaration is that his deceased sister on the next date of incident, when he meet her at DMCA's disclosed before him that accused Danjit hold his sister and other two accused persons poured kerosene oil and accused Danjit set ablaze his deceased sister. In this case, there is one oral and one written dying declaration, and both the dying declaration goes hand in hand. The statement of PW4, PW1 informant, and PW10 IO pointed at the time of recording dying declaration, victim was able to speak, and statement of PW1 and PW4 further pointed victim made statement freely in a fit state of mind, and I believe the testimonies of PW1, PW4, and accordingly their piece of statement is accepted by me. 33. Next point raised by learned defense counsel is that dying declaration is based on GD number 409 and present case is based on GD number 421. Therefore, prosecution case against accused person does not stand. As per police manual and under state government rules, every police station has to keep one register, which is called and known as general diary, and in the same diary, all conduct, act, transaction of the day noted down. Whenever police receive a jar or information, when police go out in regard to their duty, they make entry in the general diary. 35. In Lolita Kumari versus Government of UP, passed in writ petition number so and so, the Honorable Apex Court held that the general diary is a record of all important transactions or events taking place in police station. including departure and arrival of police staff, handing over or taking over the search, arrest of a person, details of law and order, other duties, visit of senior officers, etc. It is in this context that gist or substance of each FIR being registered in the police station is also mentioned in the general diary, since the registration of FIR also happens to be a very important event in the police station. Since general diary is a record that is maintained chronologically on day-to-day basis on each day, starting with a new number, the general diary entry reference is also mentioned simultaneously in the FIR book, while FIR number is mentioned in the general diary entry, since both of these are prepared simultaneously. 56. It is relevant to point out that FIR book is maintained with its number given on annual basis. This means that each FIR has a unique annual number given to it. This is on similar line as the case number given in courts. Due to this reason, it is possible to keep a strict control and track over the registration of FIRs by the supervisory police officers and by the courts whenever necessary. Copy of each FIR is sent to the superior officer and to the concerned judicial magistrate. Next, 57. On the other hand, general diary contains a huge number of other details of the proceeding of each day. Copy of general diary is not sent to the judicial magistrate having jurisdiction over the police station, though its copy is sent to the superior police officer. Thus, it is not possible to keep strict control of each and every FIR recorded in general diary by superior police officer and or the court in view of enormous amount of other details mentioned therein and the number changing every day. 36. On the date of incident, that is 1/22/2013, when deceased victim was brought to the Mukalmua PSC with burn injury, attending Dr. PW4, Dr. Pallab Kolita gave information to OC Mukalmua PS over phone with regard to bringing a burn victim in a serious condition with more than 50% injury at the Mukalmua PSC for treatment, and this is only an information given by the doctor as per his duty to the police, and said information does not disclose any other facts of committing an offense. Information of PW4 to police was just an intimation as per ethics of the doctors while treating burn victim. When OC Mukalmua PSC received the said information as per the rules, he entered the said information in his general diary, being GD number 409. On the next day, police received written adjournment from PW1, and accordingly, as per rule, on receiving the adjournment, the content of adjournment is entered in general diary, height GD entry number 421 dated 23/1/2013, and in between GD entry number 409 and 421, police might have received other information which were entered in the general diary, and GD number 409 dated 22/1/13 being only an information of bringing one's burn victim to Mukalmua PSC for treatment cannot be treated as FIR, as SAM does not give any facts of commission of the offense. Therefore, non-exhibiting GD entry number 409 does not hamper the prosecution case, and GD entry number 409 cannot be treated as first information report. More so, previously one who resided 24 kilometer distance from the police station lost adjournment on the next day at 10 or 11 a.m. Defense plea is that PWs made the different statement before the police and court, and therefore their statement is not reliable, and non-disclosure of the name of Ratul Bora, Nipon Kolita, and Pradip Kolita make the testimonies of PW1 unreliable, not acceptable as per law. Defense took plea, two inconsistent persons, one in the evidence and one before the police, and therefore prosecution case is not acceptable. 38. Once scrutiny of evidence PW1, I find that Ratul Bora, Nipon Kolita, and Tridip Kolita are not eyewitness of the case. The statement of PW1 is that he accompanied them to the police station at the time of lodging the azhar. As they are not an eyewitness to the incident, the non-recording of statement of Ratul Bora, Nipon Kolita, and Tridip Kolita, and non-examination of them by prosecution at the time of trial does not weaken the prosecution case or dampen the testimony of PW1. On scrutiny of statement of PW1, it is seen that he before the police made statement that marriage of his deceased sister with accused Sanjit is love marriage. After marriage, he was rebuked frequently by her parents-in-law, and on the night of incident at about 9:30 p.m., accused person Dhanjit, Gandha, Onima, Moromi pouring kerosene over her body that ablaze her, and his sister was undergoing treatment at VMCA. In the court, while adducing evidence, he made the same statement that accused person poured kerosene oil on the victim and set ablaze her, and the fact of deceased father-in-law wanted drinking water. He offered glass of water which he did not drink, came to his knowledge after meeting with his sister at DMCS where she disclosed the same before him. Therefore, I find that February 1 made statement before the police, which was in his knowledge at that time, and therefore this cannot be treated as improvement or major contradiction, and there is no true theory appeared in the case, and the submission of learned defense counsel is rejected being devoid of merits. 39. PW2 deposed that he heard halla of people saying this was died due to burn injury, and on next morning he came to accused house and came to know that this was already shifted to hospital immediately after the incident, and later on he came to know that after 1 week of the incident, Arati died at hospital. PW3 deposed on the next day of the incident when police came to the house of the accused. He came to the house of the accused and came to know from the gathering people that accused person set fire on the body of this is Arati Talukdar. PW5 and PW6 are declared hostile by the prosecution, and they stated they noticed that this is Arati in the courtyard of accused house who was in burned condition. In this type of cases, neighboring persons generally prefer to keep silent to avoid future complication, to maintain social relation, but the evidence of PW2, PW3, PW5 and 6 pointed on the date of incident. This is Arati Talukdar sustained burn injury. When their evidence is recorded, accused persons were bailed out, and they are living in same locality where PWs are residing. Therefore, possibility of influence cannot be ruled out, for which witnesses turned out hostile and preferred not to disclose true facts. The statement of PW3 pointed he heard from gathering accused house that accused person said ablaze deceased victim, and his statement that corroborated the prosecution allegation against the accused person. 40. Learned defense counsel mainly confined in argument. His argument, oral as well as in written, only under charge of section 304B IPC, and contended that first dying declaration is not acceptable and said piece of evidence to rely upon, and the said dying declaration does not point at the harassment in demand of dowry soon before her death, and therefore presumption under section 113 of the Evidence Act cannot be drawn. 41. From the statement of PW7, Dr. A.J. Patwari pointed that Dr. R. Sholiha and Dr. D. Chakraborty conducted autopsy on the dead body of the deceased victim. Can he concur the report as Professor Dr. R. Solia, head of the forensic medicine, VMCA, was out of station on the date of concurring the report. This evidence is on postmortem report. At the time of autopsy, burns injuries are present over the following parts of the surface areas. The lower part of the face involving the mandibular area, the anterior aspect of right upper limb up to the wrist joint, the neck and the anterior aspect of right half of the chest and abdomen, anterior aspect of the left abdomen from the middle one third along a transverse area of the breast, 2.5 centimeter, and anterior aspect of the whole right limb up to the knee joint, posterior aspect of the whole right upper limb, the posterior aspect of the chest and abdomen, that is in the back in right 2/3, the posterior aspect of right lower limb in the thigh, involving up to posterior medial part, pairing lateral 1/3 of the back thigh, the calf region of the left lower limb at place, the anterior medial aspect of the right thigh, sparing the lateral 1/3 of right thigh, the anterior medial part of the upper and middle 1/3 of the right leg. Blisters are present in the cubital fossa on left upper limb and left hypochondrium. Burn areas are covered with unhealthy granulation tissue and greenish colored fold, smelling slow and pus. Burn areas are epidermal to dermoepidermal in depth, covering around 50 to 60% of the total surface area. And on the basis of findings, opinion regarding the cause of death was due to septicemia following burn injury sustained as described. All the burns injuries sustained were antemortem in nature and epidermal to dermoepidermal in depth, covering around 50 to 60% of total body surface area. Approximate time since death is 12 to 24 hours. It is an admitted fact that deceased victim died in burn injury and died of burn injury. Statement of PW2, PW3, PW4, and PW5, and statement of PW8 clearly pointed that on the fateful night of 22/1/2013, fire caught on the body of the deceased Arati, and she died of burn injury. From the accused village, the dying declaration recorded by PW4 and oral dying declaration narrated by PW1 pointed that accused persons quarreled with the victim on the date of incident. It was accused Dhanjit who dragged her out, and thereafter all the accused person said ablaze her by kerosene oil. The dying declaration, which I find to commit murder of the deceased Arati Talukdar, poured kerosene oil of her body and set ablaze her, which satisfy the ingredients of section 302 IPC 43. To attract section 304 BIPC, there must be harassment cruelty in order to make illegal demand of dowry. The written as well as oral declaration of deceased victim does not reveal demand of dowry soon before the date, which was unnatural death and took place within 7 years of her marriage with accused Dhanjit. The dying declaration beyond a reasonable doubt and fairly established that the accused person said ablaze by pouring kerosene oil over her body and committed murder by intentionally causing burn injury on her body, and therefore after entire scrutiny of the evidence on record, I find that prosecution fairly able to bring home the charge of section 302 IPC against both the accused persons, namely Dhanjit Talukdar and Onila Talukdar, beyond all reasonable doubt, and both these accused persons are convicted under section 302 of the 30 privacy. Accordingly, their bail stands cancelled and they are taken into custody. Accused will be heard on the point of sentence on even. Thereafter, sentence was given life imprisonment with rigorous imprisonment and 25,000 fine in default, 6 months RI. There are so many discrepancy, omission, improvement, my lords, in statement of one. My lord, PW1 stated he lost FIR in the morning. And thereafter, he went to GMCS to meet his sister, elder sister. But according to the
Mr. Pandit, just take your seat for 2 minutes. You take your seat. Miss, everything depends on the dying declaration recorded by PW4. Nothing else, nothing less. But even if PW4's dying declaration exhibit 2 is to be accepted, then also there is nothing to convict the other two appellants.
Only he did it. Other two comes in the oral dying declaration.
There we find contradiction, some inconsistency there. It is possible that he has added the name of the in-laws.
But in case of multiple dying declaration, I think the last one should be believed. In case of multiple dying declaration, one of the factor is that the last one should be believed. Because PW oral dying declaration seems to be later. Doctor.
Yeah,
had
but if
first
it is a
reported.
choice between oral and written dying declaration, then-
Written, oral needs corroboration again.
and then PW4 is a doctor. Why would he? He would have no
No, nothing to do with.
no motive. Other two appellants, there is nothing.
Other two, only one,
One,
Anila,
my lord.
one abated, one died.
One died
Ah.
during the appendix, during the trial.
After recording of 313, he died.
Only
Nothing
mother
against-
and
Nothing
husband.
against Anila, except the
Anila,
oral dying declaration.
except the oral dying declaration.
Six. PW6 statement, Your Lordship. Deposition of PW6. In his first examination, he made one of the vital aspect of the entire matter, Your Lordships. May I read a state,
He sold the land for treatment.
Lordships?
Hmm.
Lordship, he,
So six term
whether
was term.
there is any direct evidence in the entire matter or not. PW6 page 19. He was declared to be hostile, but in cross prosecution, he has made a statement. In fact, it is not a fact that a hearing of hue and cry from the house of the accused Dhanjit, I noticed fire from the side of the Dhanjit's house. And I also noticed Dhanjit and his parents at the veranda of their house. Full stop. I noticed, important, I noticed after setting fire on the body of Arati by Dhanjit, he pushed her to the courtyard and then I went to the house to call my son the jointer. That is a very admitted fact, Your Lordship. Now, down below, it is a fact that I noticed fire from the house of the accused and then I returned to my house and called my son jointer. It is not a fact that I have made this deposed falsely today. That the Arati and Dhanjit is very much present in the entire incident, Your Lordship.
Arati is who? Arati is the
The
victim.
mother.
Deceased,
Is it-
no.
No, Arati is the
Arati
victim.
is the
A victim.
victim.
Anila, sorry.
You take rest,
Lordship.
because if you hurry, you will make mistake.
Lordship.
You have seen it just now.
Lordship.
Don't hurry, don't rush. We'll hear you.
My lord,
Don't mix up victim with the.
my lord, one vital point is there.
Please, Mr. We'll hear you. Just a moment. Just a moment. These matters don't take more than half an hour to decide. We'll hear you if some adjustment is to be done. So nothing against Anila. And then even this, what he has pointed out, PW6, though hostile, corroborates the version of PW4 insofar as Exhibit 2 is concerned. So nothing to it.
That dying declaration can be the sole basis, no issue on that. So doctor's PW4's dying declaration is the only evidence, seems to be. Corroborated, if at all required, by oral dying declaration. So, yes, Anila against her, there seems to be nothing apart from only the oral dying declaration.
And PW1 has a tendency of exaggeration, looks like. He said the other 3 persons were with him in the police station. Then they were present while oral dying.
Oral dying declaration.
They were neither, the IO said
witnesses.
nobody was present. He only recorded the statement of the informant. Both, he saw the informant in the police station and recorded his statement only. So the presence of these three persons
is doubtful.
is doubtful.
But let me see. the
Why would
charge
he,
sheet.
why would he rope in these three persons?
Charge sheet also, those persons' name are not there. Who are those?
Yes, because their statements were not recorded.
Never. They were not even made a witness.
They are not charge sheeted witnesses.
Kiki Namaste, beta.
Yes, yes, we'll give you the names.
I get it somewhere.
Hmm.
Uh,
We'll get it in.
Trideep Noyan.
Yes,
Trideep Noyan.
Nippon, Nippon.
And
Nippon and
Ratul.
Trideep.
Trideep.
Ratul, Nippon and Trideep.
Yes,
Three persons.
not there in the charge sheet as well.
Hmm. And the IO says their names were never mentioned, so there is some exaggeration here. Correct.
IO also statement is not very complete, even the hostile part is not brought.
Hmm.
The contradictions are not brought. Of course, he said, Champak Bora did not state before me the name of Ratul, Nippon and Trideep. And I've checked the 161 also, it's not there.
Therefore,
So,
we are not comfortable in relying on PW1
one.
oral dying declaration.
Hmm.
But we may not be averse to accepting the dying declaration exhibit 2
Hmm.
because he is a doctor, he doesn't have any motive.
No, nothing.
He
no
was
animosity.
present there. It was within 1 hour 45 minutes. He did it on the request of the police.
Police.
There is nothing inconsistent or nothing to doubt it. Signature not taken. Signature is not necessary.
Not
in dying.
necessary.
And then he has explained the
Explain
reasons.
the reasons.
Both our hands were injured,
Swollen.
swollen. So the accused gave an explanation she was trying to cook.
Hmm.
But that explanation stands belied by the written dying declaration,
Hmm.
which somehow finds corroboration from the testimony of hostile witness PW6 as well. So
304B is again ruled out. But otherwise, those ingredients were
that's the
there.
problem. We find these matters are, but anyway, we don't agree with the observation of the trial court that there is no ingredient of 304.
Dowry part is there.
There, in fact, that's what the doctor also says,
Hmm.
PW4. We don't know what is happening. These are matters which really raises concern.
Hmm.
Really raises concern.
The trial court
How
said-
the learned district judges or session
Hmm.
judges are ignoring these things.
And these are the evidence, otherwise,
But in any case, there is
But
evidence.
she died after more than 1 week. She died on 31st of January.
Yeah, and there was a stillborn baby also.
Dead baby,
Delivered.
yes. She gave birth to.
And
Okay.
what is this testimony of this witness that the accused sold his land for treatment of? How can he sell his land? and-
Yes. That is how the trial court said they wanted to have a good social bonding, so perhaps they changed her statements. The 4-6 and these hostile witnesses. 50 to 60% burn septicemia. No, I'm thinking whether at all it can be lessened down the punishment and all.
How?
She did not die instantly, of course, after 7 days. And
The mother is in the jail.
mother is bailed out.
Bailed out.
She's on bail too.
No,
Anila?
no.
Oh, Anila, I thought she's on. She's Anila.
Oh,
She's also inside. They had moved an application
more the application.
Where is that
Rejected.
application?
that is rejected.
I was filed for a bail application, but that was rejected.
Rejected by which court?
This court, my lord.
Perhaps Lordship's order.
My lord, as per statement of the PW1, in the morning, FIR was filed, lodged. And as per the IO, at 40, he lost FIR and his statement was recorded 410. That means if prior to the lodging FIR, he went to the GMCH and he learned everything from his sister, elder sister. Which one is correct? IO, according to IO, as per FIR also, as per the GDMP also, 4 PM, he lost FIR. But as per PW or the informant, he lost FIR in the morning, 9 or 10 a.m. So it is very,
Mr. Pandit, you can make all these arguments. You need not labor on the appeal of the mother-in-law, Anila. We don't think her conviction is
And,
sustainable. Listen, listen, we are helping you. Listen. You can hear us, no? Listen. Don't labor on Anila's conviction. We do not find PW1 and his oral dying declaration reliable. But we certainly find the dying declaration recorded by PW4 absolutely reliable. It is corroborated, and therefore the conviction of the main appellant Dhanjit prima facie appears to be sustainable. Confine your arguments to that. Forget PW1. PW1 is nothing
may I
to do with.
submit, my lord?
Hmm.
The dying declaration is Exhibit 2 is
Let's read it.
suffer from so many infirmities.
What is it? Show us.
Is that page 78?
78, no?
78.
Yes. 78.
78 in my paper book.
This
Dying
was,
declaration report.
this was written in third person, not in
Oh,
first person.
Uliala.
Where is the dying declaration?
It is exhibit 2, my paper book, it is 78 after the
Paper book,
sentence order.
78.
After sentence order. Your lordship good. I have examined ROT 24 years. So and so with alleged burn injury, approximate 55% with 9 months of pregnancy. And I have conducted the dying declaration of the patient at around 10:45 PM on 22nd and have recorded. The injured woman alleged that she has been frequently tortured
Tortured.
by in-laws and quarrel also took place today. And her husband has put her on fire by pouring kerosene oil over her body today at around 9 PM. The injured woman was given primary treatment at Mukalmo and referred to GMCH in a serious condition in government ambulance.
What is the infirmity here?
No signature was taken. Of the
Not
victim.
required, not required. Move on next.
Next, whether he was fit, his state of mind, that was not explained or recorded by the doctor.
Correct.
Next, my lord, and the indicate was not read over to the victim.
Is it so? PW says.
And no witness was there, no signature or attesting witness was there, no magistrate deputed for recording the statement. These are the so many discrepancies.
All right. What else?
Or whether sedatives or painkillers were used before recording the statement, that was not mentioned in the dying declaration.
All right.
Supreme Court as well as this court, so many judgments here, my lord.
What come to the what is the point? Show us the judgment. What is the point? What is the point? First, tell us.
My lord, my lord. One is penalties, whether penalties were administered or not. Regarding this, my lord, Supreme Court judgment, that is Rajendra Singh versus State of Punjab, my lord.
But have you asked? You have cross-examined the PW4.
Yes, examine.
Have you asked him?
Ask
Where? Let us see.
PW4, my lord.
Page 15, sir, of course.
What have you asked him in the cross?
Page 15, too.
Huh?
Page 15.
16.
15 for 1-5 cross examination.
Cross, my lord. It is a fact that I have recorded the declaration, page 15, my lord. 16. In a letter which was addressed to OC Mukalmoa Police Station, the victim gave the declaration Assamese. language, but I recorded the dying declaration in English. It is the fact that paper where I recorded the declaration, nothing is noted. The victim forwarded dying declaration in Assamese, and that I translated the same in English language. In a dying declaration signature of no other person is obtained as witness, and nothing is mentioned that there is any witness present where I recorded the dying declaration. It is not mentioned in Exhibit 2 that the victim was in a fit state of mind to give the declaration. It is not mentioned in that declaration Exhibit 2 that whether patient was in general ward or in cabin. Then, my lord, it is a fact, it is not mentioned in Exhibit 2 that at the time of recording dying declaration, victim was not in a condition to put signature. Nothing recorded, nothing.
Not
mentioned.
only that, it is not mentioned whether there were curtains in the room, what was the design in the curtain, whether the bed sheet was clean.
No injury was on the hand.
Where is the requirement to record all these things, Mr. Pandit?
It is not mentioned. It is not mentioned whether any sedative or painkiller was provided to the victim prior to recording the dying declaration.
Right.
Regarding this judgment also, my lord.
Yes, it is not mentioned.
Not mentioned.
Where is the law which says all these things has to be mentioned? Show us that law.
So it is then not acceptable.
No. There is no such law. There is no such law.
My lord, I am mentioning then.
When a doctor records the dying declaration, if you do not make a suggestion that she was not in a position to speak, how do we expect the court, the appellate court now to reconstruct that scenario and come to a finding that doctor was lying? What is the interest of the doctor? And then you should have brought out those things in the cross-examination.
It is maybe sole basis of conviction, but conviction can be based solely on the dying declaration, provided if it is free from infirmities and capable of acceptable by
That's
court.
correct. That you are right. You are right. Where is the judgment? Give it.
My lord.
Give that.
Another, my lord.
Yes.
Discrepancy in testimony of witness caused by memory lapses. But this
Mr.
particular
Pandit, there are 5,000 judgments on criminal law on various subjects. Don't go to points which are not relevant. What is the point here? We have told you that the conviction of Anila, we don't find it.
My lord.
We don't find the oral dying declaration as acceptable. There is no corroboration. There is discrepancy. But insofar as the dying declaration recorded by the doctor in writing, that appears to be correct, firm, finds corroboration, and therefore acceptable to the court. You are arguing on points which are not legal matters. If you have to make out a point saying that she was not in a fit state of mind, and doctor was also asked this question, he could not answer. Then we can see whether anything is mentioned, that. These are not required to be mentioned in the dying declaration. So he is not mentioned, so what? So many things. Is the doctor writing a thesis?
It was not proved by GDNT also.
That is
My lord, 409 GDNT also not produced in the court in support of the dying declaration, my lord. My lord.
All right.
My lord.
You conclude now.
My lord.
Yes.
Guwahati High Court also, my lord.
Finding out the
High Court,
session judge also did not record any finding regarding common intention, etc.
According to Guwahati High Court, my lord.
Yes, those 34.
34 has been mechanically.
Mechanically, most of the cases it happens. No findings on 34. 34 to show common intention, again we have to go back to the oral dying declaration. Because he has to.
My lord, the love marriage was marriage was solemnized by love marriage, and lady was pregnant, 9 months pregnant. It is not possible to kill by her husband by pouring kerosene. It is not possible, my lord. In the FIR also, FIR reflect that it was love marriage, and the lady was 9 months pregnant. But how he can kill his wife as well as his own child by pouring kerosene? It is not possible, my lord.
No
It is
emotional.
possible and what
No
is not
emotion.
possible.
My lord, as per Guwahati High Court, the declaration should be taken down in exact words of person making it. It should be ifsi sima bharba of the person making it. এই হব লাগে বুলি কৈছে স্যার, এই ধরনেও তার মানে খালাস দিছে, my lord. This is my humble submission, my lord. So many here 7 or 8 judgment, Supreme Court judgment are here 6 and 2 judgment of Guwahati High Court regarding dying declaration only. And sterling witness, he cannot be sterling witness because his capability and he is not trust, his person is not trustworthy, because according to him they are lost in 9 p.m.
We agree with you, Mr. Pandit. We agree with you.
My lord.
Don't spend your breath on convincing the court things which have already we have said we agree.
My lord.
We disagree with you that the PW4's dying declaration is not in accordance with law. If you want to say anything on that, argue.
My lord, exhibit 2, dying declaration, written dying declaration, my lord. So many things was not mentioned by the doctor, and GDNs also not produced to support the already one victim, the doctor and a police also involved in conceal the actual fact.
How did you know about these things? Where did you come to know? Police is involved. Where?
Already been arrested.
Somebody told you?
Already been arrested. Already been arrested.
No. These things that you are saying, police is involved, doctor is involved.
No proof,
How
my
did you
lord.
know?
My no proof, but it may be later on. It may be made later on. This exhibit number 2, with the help of doctor and IO.
Then you convince us, you point out.
According to our defense is, she was cooking at only 9 or 9:30. 9:30, all ladies or wives or female cooks at 9 or 10. She was cooking. At the time of cooking, fire caught and she died. And they, according to exhibit witness number 3 also, 5 also, they stated, he stated that they tried to, father-in-law, mother-in-law, or he also, the husband also tried to put out the fire by pouring water as well as by throwing gunny bags. These are the statements, my lord. My lord, consider this, my lord.
Anything else?
And if they did such evil deed, they might have stayed away from the spot. But the person who attended, they told they were standing nearby the victim. So there is no possibility. Then the appellants killed the victim by pouring kerosene on her body.
All right. Yes.
No, as far as Lordship is correct in saying oral dying declaration requires corroboration, that is not here. So we will be confining ourselves to the dying declaration, exhibit 2. So exhibit 2, it's clearly very short, very precise that he is the one who had poured the kerosene. So as far as he pouring the kerosene, I think that is enough, or setting her on fire. So at best, what I can say is she, in the dying declaration, the quarrel part is there. She died after 7 days. By that time, even magistrate could have been brought and her statement could have been recorded. And she was there for 7 days and he was there present at the place of occurrence even after the occurrence. So seeing this, that if at all it can be reduced by taking into, because it seems that intention to kill her perhaps was not there. If at all it can be brought down by taking recourse to exception 4 without premeditation in a sudden fit of anger, that can be done. In my humble submission, that can be an option. Otherwise, killing he killing her is there by the doctor. He has no animosity. He is there. He treated. He informed the police. He then, on the instruction, he recorded. But there is no infirmity. Short, very nice, precise.
Yes,
this is-
dying declaration should be in the language
Hmm,
of the victim in so far as practicable.
hmm,
But if it is a one-liner or a two-liner
hmm,
and it is recorded by a doctor,
hmm.
then the court will have to see whether a doctor can be believed to be a person without even that much of education,
Hmm,
that he cannot translate a simple line,
hmm.
that there was a quarrel, my husband poured kerosene on me
Mm,
and set me on fire. This is not a complicated verse which requires literary skills, etc. So this much can be written by anyone from any language to any language.
And he said, she said in Assamese, I translated and I wrote in English in his deposition. English is not very good, but then he translated it and he wrote it.
English is not very good, goes many places, not only.
Ah,
Why only
yes.
talk about
No,
doctors?
yes, because the way he has written, there is a quarrel today, but then still it's okay.
And what nowhere stated by the PW1 also, then there is a quarrel between husband and wife, that is sister and the victim number 1, the accused number 1. Nowhere stated,
It's stated by the victim, it's herself in her statement.
except
Ah,
victim. The victim also not stated, their quarrel took place today with my husband. Nowhere stated. In the dying declaration also. Nothing stated.
No, he said, the doctor has mentioned that quarrel took place even today.
quarreled, what he's saying with the husband. That is not there, not in so many words. She had been frequently tortured by in-laws
In-laws.
and quarrel took place today. And her husband had put her on fire by pouring kerosene today at around 9 p.m.
And FIR reflects that accused number 2 has ill intention to cohabitation with the victim, the father-in-law of the deceased.
That
FIR
is
it-
only in the FIR, not
As per
the
the FIR.
substantive piece, yes. He died, he had,
As per the FIR.
only in FIR.
So let us take it that we are interfering with the conviction of the mother-in-law. Due to want of evidence, there is no finding on common intention, etc., etc., and at least some observations were called for.
Hmm.
And both the main accused and the mother-in-law, both of them have given explanation.
Hmm.
But the father-in-law has not given that explanation.
Father-in-law,
Yes,
no, after 313. He gave his statement in
Yes,
313.
but he did not say she was cooking.
Uh-huh. He did not
Is
say.
that correct?
It is false. Yes, a statement for the court. I cannot say whether dying declaration. I know, yes, I cannot say. No, he did not say yes. Only mother-in-law and the accused said.
That is also
Huh.
one factor which cannot be brushed aside.
Hmm.
3 persons were at home.
Hmm.
2 gives this explanation, but the father-in-law, so father-in-law in all probability had nothing to do with this. Probably the mother-in-law had some role,
Hmm.
but then we have to go by the principles of law. We cannot reconstruct what has happened in 2013. We have to go by what is on record, what is, and give our reason. In the event we accept your argument that it could be a case of conversion. What kind of sentence would you propose?
Without intention, but with the knowledge. So of course, 8 years, 9 years, I would say. He has been inside, perhaps from the date, paper, no? 13 is the occurrence and he was inside here.
Seems to be what we discussed.
Ah.
Yes, what do you have to say?
He's in fact,
No, I'm asking. Yes,
Mr. Bora.
yes. Anything, Mr. Boyd?
He said,
there is a material for dowry demand.
Hmm.
If there is a material for dowry demand, there cannot be conversion, madam, because it's a 302 then. There's intention is proved. Then it's 302. There cannot be revealed sentence.
Material for dowry demand, which the trial court has rejected.
But if lordship finds it there,
Hmm.
it's a perverse rejection. If there is a material for dowry demand exists, then the intention is clear. If the intention is clear, there cannot be conversion into which. If the 304 becomes, then 302 automatically comes.
no, in that case, I differ because 304B ingredients are different, 302 is different.
When there is a
Both cannot come together.
I'm sorry to say, madam.
Acha,
There is a
maybe,
judgment of the Supreme Court in all cases of 304
Uh-huh.
P.
yes.
302 is affirmative.
Uh-huh.
Where
That
it is a, where, insofar as practicable.
Huh.
Yes,
It is not an absolute right.
but when it's a, then it is a matter, madam. The intention is there.
No intention.
If there is a full material of dowry debt is there. Lordship, I just heard it there is a material for dowry debt. That's why I'm saying that she is trying to reduce it. That's why I'm saying, if there is a material for dowry debt, it has been established by the evidence.
Would you, Mr. Bora, since you have come forward, would you have a look at the dying declaration, written
Sure.
dying declaration once?
It is.
And if the dying declaration, oral dying declaration, is corroborates with the written dying declaration, then matter is ends, madam.
It corroborates partially. Insofar as the main accused is concerned,
Yes,
he has been implicated in the oral and written both.
then, my lord, then.
But the oral dying declaration also ropes in the other family members, the
Maybe, my lord, that is an exaggeration, but it's ipso facto cannot brush aside the entire
That's what we are saying.
evidence. It doesn't go. It may be,
Written dying declaration recorded in about 1.5 hours of the incident
yes.
in the primary health center by a doctor. At that time, he says she was in a position to speak. And it was a
And what is the injury? I don't know much.
50%
burn
injury.
Burn injury, if the kerosene is poured, my lord, generally, the burn will start from the head. I don't know what is the evidence here. If the burn it starts from the head, it is always difficult for 60% if the face is gone. I don't know what kind of injury. That is very important while giving the dying
Lower
declaration.
part
If
of
the
the
lower
face.
part is there,
No
then
single
yes. There can be a dying declaration.
Lower part.
If the fire
lower
starts.
part of
bottom-
This is first the lower part of the face, involving mandibular area. Then anterior part of limb up to right joint, wrist joint, limb or wrist joint. Then neck and anterior aspect of the right half of the chest and abdomen. Anterior aspect of left abdomen, anterior on limb,
At the face.
lower, তাৰমানে তলৰ পৰা আহিছে, তলৰ পৰা আহি the lower first.
There is no injury, the burn injury on the face.
Cranium part, upper
Yes,
part.
yes,
That is where the sensory part is there.
yes. Then yes, dying declaration can be possible, even 60% in the lower part. But if it starts from the head, because the kerosene generally, you put it from the top panel. Very difficult to put it from the down and the burning. Then, yes, and my only concern is that if the dowry demand is established, madam,
Followed.
then the intention is automatically there. Then we cannot say that this is a 304 part 2, because intention is dowry demand. When the 304 part 2 is concerned, the 302 is automatically comes. That is my understanding. Just what I have heard from the website.
My lord, no seizure, no lamp was recovered, seize, no burn cloth is recovered by the IO. No seizure there in this case. According to PW1, the poured kerosene from the hurricane, that is lamp, that lamp was not recovered, not seized by the IO.
Lamp is not necessary, but the rest of the things is necessary. The wearing apparels, that will show, my lord.
No, but if the wearing of apparels is not seized in the on the face of the medical testimony, the evidence of testimony of doctors, medical.
How it has been removed, there has to be something, my lord, how the wearing apparels, who has removed it? The doctor must have removed it.
Yes, but she
Or-
was also pregnant and she was
Yes.
operated upon.
Then the
She was in the hospital for 7
so,
days.
so that wearing apparels,
Hmm.
where it has gone, my lord, and the other things that during the, probably she was immediately taken to hospital, my lord.
Immediately.
Yeah,
Rushed to-
immediate. She was only
So
clad in a
immediately,
mekhala. And then
That
she
means
was
that,
Some witnesses said she was wearing a mekhala.
mekhala only.
so Mekhala is not seized, probably there is a possibility that it was removed by the doctor in the hospital, because the operation was required.
Mhm.
In
But that has not
case-
come in the evidence.
That has not come in the evidence, but it is the duty of the defense, obviously, to how it has been just suggesting that it was, because she was definitely wearing something, that's why the burn has caused my life. Otherwise, how can it there be burn without the appearance? It has ignited the fire. So she has taken to that is the, but if she is wearing the mekhalas, and it must be removed during the hospital for during the post-mortem and before that also, because cleaning
Correct.
that's what I'm saying. And my only concern is that much, the 304 dowry part has been established, then it is difficult to reduce the sentence.
No, that is, there is
That is
no
not-
dispute. It has to be culpable of homicide not amounting to murder. Then only we can
No,
reduce.
that is a
Huh.
new angle he has brought in. In fact,
But then
Because
302
Then
and
it's become a murder, my lord, because the intention is there, my lord. The moment dowry demand is there, that's the intention.
But 302
That's
and 304B ingredients are totally different. Conviction cannot be under both. Conviction can be only under one. There are high court judgments. I
Yeah,
have
that's
taken it out.
That's-
So 302 this is a case finally convicted under 302. That is how I'm saying this can be culpable homicide not amounting to murder. That is how I'm praying for reduction. Hey, this is my humble submission looking in the facts. But 304B, if we go to that, then we will have to confine ourselves to 304B ingredients only. There, this 304 and all will not come.
no, but if you go to 304B, then the mother-in-law, the other appellant automatically is roped in. There is no further evidence that is required.
Hmm,
But she has already been acquitted of 304B by the Learned Trial Court.
hmm.
How do you now convict her on
No,
304?
charges are under there. So,
The murder may not be 304B because it is acquittal. And the state has not preferred any appeal probably against that acquittal. But there's the other material for 304 dowry. Dowry demand is if it's established, beyond reasonable doubt. That is why I'm saying when the dowry demand itself is proved, if it is proved beyond reasonable doubt, then the automatically 302 comes. It's a homicide then, because it's an intention is there. The person who has killed him, maybe because of the dowry, that's just a reason. Dowry is just a reason, nothing more than that.
Yes.
And the reason is, but it's a homicide. He has killed him. The reason is only for the dowry.
That's the motive.
That's the motive, the dowry. So the motive and the motive means the intention. If the intention is there, then where is the reduction, my lord? 302 is always there. You
Fine.
can't. So that's why Supreme Court says in all cases of dowry death, in the framing of charge, 302 has to be there. Has to be there. There's no.
Rightly so.
but then I differ in a particular point. Supreme Court said this 302 should be added only because of the reason 304B doesn't provide death sentence. That is how it was directed to be. Yes, those judgments, Lordship, I had shown your Lordship that day.
Anyway, we'll
On
go into
merits
that
again.
debate some other day.
I have few
Because
high court
only-
judgments.
Only
where-
because of the sentence,
Hmm.
no particular sanction is applicable. Sanction is applicable only material of material manner, not only because of the sentence is something else. In there is a death sentence, there is no death sentence. For that reason, my humble opinion, there may be a judgment, I don't know, but it's a par imperium judgment as per the law is concerned. If that is be so, we do not go by the sentence, we go by the material of the particular section. 302 is something 302.
Yes,
304B.
302, there must be clear intention.
Yes,
It must be a case of culpable homicide,
homicide.
amounting to murder. And these facts have to be established beyond reasonable doubt.
And the
I can-
fact remains that whether these deaths took place within the 7 years or not, I don't know.
Yes,
Yes, yes, one
one
year.
year.
Within
2 years.
then
That's what we
Yes.
observed a little while back.
Hmm.
It's surprising how the learned district
then the
judges.
presumption is mandatory. It is shall, not is may.
It's a clear case of conviction under 304B, at least.
The materials are there.
Because it is the may. The presumption in that case is of shall, not may.
That presumption ought to have been displaced by. them. They have
Rebutted
not
by
done-
the appellant. He has
they
to
have not
rebut
done
it.
So,
If that's not rebutted, that the dowry regarding the dowry part, that will remain, my lord.
yes, but the problem is, again, coming back to the other issue. If the learned trial could have convicted both of them under 304B, then it would have been difficult for the mother-in-law to get out.
Well,
But there has been
my
an-
humble submission is the mother-in-law may not be sometimes convicted for 303. He may not be. He may not demanded anything. There may not be any
No,
cleansing.
no, there
evidence
are,
against-
that the dying declaration itself says that it is the in-laws.
Yes, but
In-laws.
the fact remains that the one probably he is acquitted because of some reason. Maybe it is perverse, but for that benefit, he cannot be, the husband cannot be.
The husband cannot get, we made it clear. in the
The husband, because the mother has acquitted because of the misunderstanding or whatever may be. But that benefit will not cover the
No,
husband.
no, that,
So then it can be a 304B or reduction in the sentence. It's a 302 case. The motive is clear.
followed. Yes,
That's all.
thank you.
Manslaughter is not proved.
Huh?
Manslaughter, intention is not
All
proved.
right, all right.
Only that I have two judgments, what he has just said.
Okay, you
Delhi
both of
High-
you want to argue some more, then we'll come back. We'll come back there. You have some matter, Mr. Bora?
No, my lord.
We'll come back, then we can, in the meantime, if you want to place anything more, you do it. 5 minutes, 10 minutes.
Gotcha.
we'll come back.
decisions. One, there was a Delhi High Court judgment where it is said conviction can be under both 302 and 304B, but sentencing has to be under only one. Thereafter, that was 2010 or something. Thereafter, Allahabad High Court or what High Court, I'm not getting it now. They said even conviction is not allowed because both ingredients of both the offenses are different. So here, as Mr. Bora said, 304B ingredients are there, 302 automatically comes. That I'm not agreeing because 302 is totally 302 with the intention to kill someone they have killed. It can be culpable homicide not amounting or amounting. But 304B, 5 ingredients, if they are fulfilled, then Lordship can convict it. Here is a case where 304B, both are acquitted. I think there is one judgment where it is said High Court, even without there is an appeal from the state, can enhance the sentence by giving notice to the convict. Suo motu. But here they are acquitted of the charges. So 304B, in my humble submission, bringing it again will be difficult. 302, it is established. 302, there is a dying declaration. So that is how I'm saying, not amounting to murder, if Lordship goes to 3 culpable homicide, not amounting to murder, then by taking resort to 4, it can be at best reduced. 304B again, although ingredients are there, without there being an appeal from the state, again bringing it up, because I know only enhancement can be done suo motu by the High Court by giving notice to the convict. As far as after acquittal, I don't have any judgments on that. If your Lordship wants me to bring those judgments, then Lordship has to give me some time. Delhi High Court, this one, or suo motu High Court can do this again.
Then we'll have it tomorrow then.
Lordship.
Tomorrow we'll take it up again. She wants to show some judgment. If she succeeds, then it will benefit the appellant. Therefore, Mr. Borua, anything you want to say? Take down, heard Mr. S.C. Pandit, learned counsel for the appellant. Also heard Mr. S. Jahan, learned APP, Assam, appearing for the state. Stop, Mr. H. Borua, learned legal aid counsel is appeared for the respond number.
I'm engaged by the.
Mr. H. Borua, learned counsel is present on behalf of the respond number 2. Stop. On the request, the arguments of appellant's counsel has been heard. However, on the request of Ms. S. Jahan, learned APP, Assam, we direct this matter to be posted again tomorrow. That is, give the date as a fixed part-heard matter.
Lordship.
So any other matter, part 2, ready hearing?
Item number 12.
You did not come the other day.
My lord, I am sorry, my lord, my mother is ill, my lord, so she was had to be hospitalized. I am very sorry, my lord. But I informed the my lord court master, my lord. I am sorry, my lord. Your lordship has heard the
Mia is
matter, my lord.
coming. Mia is coming. She's dealing with this matter. I'm there.
My lord, conviction has been based, as I pointed out,
You don't have a good case.
corpus delicti, that body could not be recovered. Here, my lord, I have checked, my lord, that lordship inquired that this PW4 was taken by showing a dagger. That dagger part is not in his 161 statement, my lord. Dagger part is absent, my lord, that I have checked with, my lord. So
Yes.
far as subject to consideration of my lordships and my lord, this PW4, my lord, on 2 counts, possibly learned court below ought not to have relied upon his evidence because of the fact that my lord, this PW4 had animosity with the appellant, first of all, my lord. Secondly, he kept silent for 20 to 20 days before giving his statement before the police, my lord. Immediately, he kept silent for 20 to 22 days. And thereafter, my lord, as my lord affair was lost, he came forward and
gave the statement, my lord. Possibly these two aspects, my lord. The appellant approaching this PW for his assistance in disposing of the dead body, my lord. Possibly this is also unnatural, as well as his conduct of keeping mum for, my lord, with all respect, my lord, 20 to 20 days after his health was sought by the appellant, my lord. That is my humble submission. And in this regard, my lord, I cited last occasion one judgment, my lord. That is in respect of a extrajudicial confession, my lord. My lord, I try to pray parallel, my lord. That in this case, my lord, paragraph 14, my lord. Third line, my lord, he further admitted that for the first time he told about the extrajudicial confession made by the appellant to the investigator so and so. He admitted during the cross-examination that he did not disclose about the confessional statement to his wife as well as to his relatives and relatives of Noor Bhai. The witness further admitted that the way leading to the bus stand passes by the police station, which is at a distance of so and so. The conduct of this witness, in our opinion, is inconsistent with the conduct of any ordinary human being. Moreover, the witness was also suspecting that his wife was having illicit relation with the appellant and she had disclosed to this Noor Bhai. It would be highly improbable that the appellant would take this witness into confidence. In this case, my lord, taking his assistance, my lord, to disclose about such a heinous crime if committed by him. In addition to this, Devaram could not have waited for 5 days to disclose the alleged confession made by the appellant to him, but on the contrary, he would have either on the same evening gone to police station to lodge a complaint on the basis of the confessional statement of the appellant, or would have gone to the house of Noor Bhai to inform the family members about the confessional statement of the appellant. The entire evidence of Devaram appears to be totally artificial. The trial court and the high court have totally ignored these inherent improbabilities in the evidence of Devaram and have erroneously accepted his evidence as credible. Here my submission is this, my lord.
Yes.
Because of the animosity, my lord, possibly, my lord, with all respect to repose a condition, my lord, confidence in PW4 that he would not disclose to anybody if I take his assistant, possibly, my lord, that is, my lord, not natural. So far as
So is there a sterling witness here? PW4?
he is the only witness, my lord. And the learned court below relied upon his evidence, my lord. Secondly, with all respect, my lord,
So Ms. Bhuya, you are appearing?
Yes, Lordship, once your Lordship had heard the matter and asked us to prepare a short note, I have already made.
Okay. If you could just have a look at the LCR
Yes, madam.
and the case diary particularly,
Yes.
and tell us what is the statement of PW4 under 161? Yes,
my lord, another aspect, my lord. Here, my lord,
just let us read PW4 once.
my lord. Page 15, my lord.
Yes.
Well, I know both the parties. The incident took place about 4 or 5 years ago. I was at home. Deposit went to my home at night and called me. There was a girl named Shuru at Deposit's house. Accused said that the girl had died because of burning. She died by burning herself. He asked me to dispose the dead body. I did not go. I had to accompany the accused as he had threatened me to kill me. I went along the accused because he had threatened me by showing a dagger. I stopped before reaching Kiop River. The dead body was carried on a bicycle. He had thrown the dead body and returned home. He warned me not to disclose to anyone. At night, Devojit stayed in our house. Police recorded my statement. I gave my statement in court also. Exhibit 2 is the statement. under section 164, exhibits so and so are my signatures. Now cross part, my lord. House of accused is adjacent to my house. There was no one in our house on the day before the incident. There is another house near our house. On being asked by police, I told that the incident had taken place about 22 days ago. I told that the incident had taken place 2 weeks before the police asked me about the matter. For 2 weeks, I did not tell anybody about the matter. I did not see the incident of burning. There was a case on the accused Devojit that he killed my uncle. He got acquitted from the case. We do not share good terms with Devojit's family. It is not a fact that I have adduced false evidence. It is not a fact that this case is based on false grounds. Then another point, my lord.
Yeah. Yes.
Another
Yes.
Another aspect, my lord, he in his evidence has stated that the body was being carried in a bicycle, my lord.
Hmm.
Had there been a availability of a bicycle, my lord, why I would approach him for his help, my lord? I will simply put it on the bicycle and throw it on the river, my lord. His assistance is not required for putting it in the dead body in the bicycle, my lord. Secondly, my lord, he said that on the day of disposing of the dead body, he slept in his house. That part also is not there in 161 statement. Possibly he intended to show that threat was, my lord, there, consistent. But so far as threat is concerned, my lord, dagger part possibly is not there in one.
So are you denying that the girl was in the house where the accused was there?
No, my lord, I am admitting it. But the fact is this, my lord. The incident.
What happened to the girl? What happened? Where is the body?
My
And how
lord,
did
as
she-
313 statement, he has said that she left the house on her own. She went missing on her own. That is
So
her.
a minor girl
My
of
lord, that is
about 9-10 years,
That is,
she suddenly left the house on her own.
my lord, but this appellant kept silent, did not inform anybody. The other family members also did not, my lord. The other family members, the elder brother of the appellant, he used to reside 1.5 kilometer away from the house of the appellant, my lord.
No, but the appellant resided in the same house.
My lord, see same, but on the alleged date of occurrence, my lord, whether it is on 24/6 as told in 164 by PW4 or prior to 22 days ago, the victim was with me, that evidence is not there. She was under my custody as well as my mother, but my lord, prior to 22 days ago or on 24/6/2015, my lord, she was with me. That evidence
No,
is
no,
missing.
not with you. She was in the house.
My lord, that is accepted, my lord.
That evidence is there.
My lord, that is evidence there, but on the date of occurrence, according to PW,
No, Mr. Das, you
Fine.
see, we are not talking about an adult male member. We
Mine.
are talking about a minor girl.
My lord,
child.
understood, my lord.
She was adopted by the mother of the
Mine.
appellant,
Mine.
right? So this is her normal place of stay, the
Mine.
house of the appellant.
Mine.
But the mother had left the house.
Mine.
And it is the accepted position that the victim girl was left behind
Mine.
in the custody of the appellant.
Mine.
Custody word has to be understood here. It is not that there is a formal custody. Appellant is the adult in the house and the minor girl is there.
Right.
She goes missing.
Right.
And for about 20-22 days, nobody is informed.
Mine.
Then comes the evidence of PW4,
Mine.
who narrates the incident
Mine.
as to how he came and asked his help
Mine.
to take the dead body and dispose it off.
Mine.
He has given,
Mine.
and he said that he did not inform anyone for about 2 weeks because the appellant had threatened him.
Right.
Threatened him in the evidence he has mentioned about a dagger, maybe in 161.
It was not
Threatened
possible.
how, that was not
Right.
stated. Anyways, now the only explanation coming from the appellant
Mine.
appears to be completely improbable for the 3 reasons.
Mine.
Number one, why would a minor girl leave the house like this
Mine.
without any reason?
Right.
And then where will she vanish? Where will she? Dead body has not been found.
No.
Where will she vanish?
Right.
She cannot just vanish in thin air. Second, if that was the case, why did he remain silent for so long?
Mine.
That's the second.
Mine.
And we do not find anything really intriguing
Mine.
to put a serious question mark on the testimony of PW4. There are delays, but the explanations appears to be there. Because this appellant has a very, he's a known criminal according to the evidence. He's involved in a murder case.
Mine.
He's known for antisocial activities. Therefore, it is quite natural that people will be scared if there is a threat
Right.
perception. So if you stitch all these things together,
Mine.
then where is the scope to presume that something else might have happened? What might have happened? At least the accused, if you would have given some explanation that
Mine.
yes, somebody else came and took her away and
Mine.
from there she went missing.
Mine.
And in so far as corpus delicti is concerned,
Mine.
there the judgments are there. I think there are
Well,
one or two
Lordship's
judgments.
judgment is
Yes.
also there, my lord. There, my lord.
If it is proved that the victim disappeared from under circumstances
Mine.
where the involvement of the accused is prima facie established,
Mine.
and there is no possibility of recovery of the dead body,
Mine.
then this principle will come into play. Now, if we do not trust PW4,
Right.
everything goes.
Mine.
If you trust PW4, then corpus delicti is not a sine qua non.
Not a matter.
If you just put the victim dead body in a bag and thrown it into the river, then how can that dead body be found? It cannot be found.
My
So-
submission is also not that, my lord, because of the dead body, non-recovery of the dead body, he should be acquitted. My submission is not also like that. my lord.
Hmm.
I am submitting, my lord, PW4, my lord. PW4 ought not to be relied upon by the learned court below in absence of other corroborative evidence
Hmm.
to base the conviction on the against the appellant.
What corroborative evidence will be
My
found?
lord, recovery, PW2 says, my lord, he saw some garments, burned garments, my lord.
PW7.
PW2, my lord.
Acha, 2.
Two.
No, certain.
No, two a portion is right.
Who has said so?
If I am not wrong, my lord. Page 10, my lord.
He also says this is an extrajudicial confession.
My lord, but it is, whether it is in front of police or in absence of police, that is doubtful, because immediately police came there, my lord. I made the accused and the husband told me that I question fled away from the, I managed to court him, subsequently police came to the accused, loose character, prior criminal university. The police,
Page 11.
page 11.
So he has mentioned that there was half burned apparel in
But
the.
that was not recovered.
And in 161 statement, he did not state this thing.
That was not recovered doesn't mean it was not there.
No, 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 in 161 of this PW2, it is not mentioned that it was put to him. Lordship will kindly turn to cross party.
Hmm.
My nephew Kamal Bhai intimated about the incident. Thereafter, I lost the other prior to 22. The girl had disappeared. Sumitra Banika was under medical treatment, so she was out of station at the time. 5 months earlier, the incident, I went to the house of the accused, and at that time, everything was normal. I came to know the incident on a date of, but I told about the recovery of the hard-burned apparel, but the police did not recover and seized it. I did not see the sack which was kept in the homestead of the. It is not a fact that accused did not tell me that he kept the dead body in a sack in his homestead. And later on, I had heard that the wife of accused has consumed some poison. When I lost the other, Sumitra was in the house of other accused, which was about half kilometer away from the house of accused, and she told that Sumitra might be there somewhere in the village. But immediately police, on the date of arrival of PW2, police also came there. So non-seizing of these things, my lord, that creates a doubt.
No, Mr. Das, we have been repeatedly saying
Ma'am.
this. Of course, you are entitled to argue.
Ma'am,
There are many things the police doesn't do,
but my lord, possibly.
but many things police not doing merely by pointing that out, there will be no acquittal,
Ma'am.
at least not from this
Ma'am.
question doesn't arise.
My lord.
You have to show that there is a genuine doubt or the chain of circumstances have not been proved.
My lord.
Whether the chain of circumstances are proved in a particular case
My lord.
will depend on the facts of that case.
My lord.
You cannot expect the IO to bring in things which are not possible.
My lord. My lord.
If dead body is put in a sack and thrown in the river,
Hmm.
then non-recovery of dead body will have no bearing in the
My lord,
case. But
But
whether there are evidence to show that how the dead body was thrown into the
My
river, that is what will be material.
my lord.
Now, these people say that he had held out threat to them,
My lord.
and he is a man with criminal track record.
My lord.
In fact, he was involved in the murder of a person where he got acquitted.
Right.
That's all right.
My lord.
But there was a charge,
My lord.
and the acquittal must be because of many 10 things the police did not do out of 12, which is the normal.
Possibly. My lord. Possibly.
Police does about 8 or about 2 or 3 things
Right.
about the 10 which is required.
Right.
That is the normal standard.
My lord.
But we cannot completely, you see, go by what the police has done and not, though it is a relevant consideration. Investigation has to be done properly.
Right.
Evidence has to be collected.
My lord.
Charge has to be proved.
Right.
These are obviously there.
My lord.
But merely because somebody has not said something or police has not
My lord.
done, seized some burnt apparel. For example, in this case, you are saying there was burnt apparel, but it was not seized.
My lord.
All right, it will have a bearing.
My lord.
In the facts, we'll see what bearing it has.
Because allegation is that this is died because of burn injury. That is why I am submitting, madam.
Hmm.
The allegation, the prosecution case is this is died because of burn injury. And
No, but
PW,
please tell us one thing.
Right.
If the evidence that the victim's dead body of the victim was put in a sack and disposed of in the river,
my lord.
she did not die of burn injury. Even then, the charge under 302 will be established.
My lord, no, my lord, lordship judgment so far as I understand, my lord. Because in that case, dead body was, the deceased went missing from Shillong. So the vehicle of the deceased, my lord, it was recovered from the custody of the appellants, my lord, in that particular case.
Hmm.
So far as another judgment of the apex court that lordship has cited, my lord, and relied upon, my lord. In that case also, my lord, recoveries were made from the mobile phone was recovered from the custody of the appellant, though dead body was untraceable, my lord. So that is why I am submitting, possibly, my lord. I may be wrong, my lord, or do you point to
No, no,
modification,
you
my
have
lord?
to argue.
That is why, my lord, that recovery of the, my lord, burnt apparels, my lord, that would have established my connection with the death of the deceased. Non-recovery of the same raises a serious doubt whether the deceased died because of burn injury or she went missing on her own or what had happened to her. Because principle would be, my lord, it is to be proved beyond unreasonable doubt, my lord. And when the question arises, who might have killed her, then only the doubt creeps in, my lord. And in all respectful submission, my lord, when that doubt creeps in, possibly, my lord, that doubt, benefit of that doubt goes to the appellant. So far as my understanding.
That's
goes, my
correct.
lord.
So we are asking you, why did he remain silent and why
My
did
lord,
he?
106, possibly 106 burden under 106 will come upon me under Evidence Act. But for that, my lord, prosecution has to establish the fact that I am the appellant who has killed the deceased, my lord, or who is instrumental in her disappearance, my lord. Because he has a lame excuse,
That exactly is what the prosecution has established through PW4.
my lord. But I have submitted why PW4 should not be believed. my
That is
lord.
another matter.
That why
If
should not be believed?
PW4 is not believed,
If we leave it in
but
my
if PW4 is believed, then all your arguments are taken care of.
will be gone, my lord. That would be gone. That is why, my lord, I am submitting, my lord. My lord, I have animosity with PW4. The allegation against me was that I killed his uncle. Lordship will kindly appreciate, my lord, subject to, my lord, my submission. my lord.
Yes, please.
Allegation against me was that I killed uncle of PW4, my lord. It is an admitted fact and it has come in evidence that I do not share good relationship with the family of PW4, my lord. Then under what circumstances, my lord, this appellant would go and take assistance with all respected condolence, my lord, of PW4 in disposing of the dead body. He would be the last person in the world that PW appellant would go and approach that I want your help in disposing of the dead body. That is my humble submission. That itself is unnatural. And he kept mum for 20 to 22 days, saying that he was given threat. My lord, there is no threat that subsequent to, with all respected condolence, 24/6, as per his date given in 164 statement. There is any threat given by this appellant on PW4, my lord. Neither he informed his family members. He could have gone to the village headman that don't disclose my name. Please, this has happened. Inform the police, madam. That was not done. He did not went to the house of the other family members of the deceased, my lord. That she is missing. So please inquire this matter. That was also not done. He simply kept mum for 20 to 22 days. Hereafter, when the affair lost, he immediately came forward and gave his statement that I was instrumental in disposing of the dead body. And third point, my lord, if cycle was used in disposing of the dead body, why I would take his help at the time of, my lord, putting it on the bicycle, my lord, I alone can do. And she was a minor girl, 10, 12 years. Had it been a fat man, my lord, with all respect, of 60, 70 kg, that logic would be applicable, my lord, that I take assistance of another person. Here, 10 to 12 years of the deceased, so, my lord. So why I will approach him and take help in putting her in my bicycle? That bicycle itself was not safe.
So what is the motive of PW2? Then he has also implicated the accused.
My lord, with all respect, my lord, PW2. No, he simply says that, my lord, the girl was put in the custody of the mother of the appellant, my lord. In the mother of the custody of the appellant, thereafter she went missing, my lord. And because of his possibly past criminal record, my lord, everybody doubted that this man is involved in the missing of the deceased, my lord.
Who informed the police? The PW2.
Mine. PW2, my lord. This is the maternal uncle of the
Anything else?
regarding the conduct My lord, regarding the conduct of PW4, my lord, may I please handle two judgments, my lord? Prior to that, my lord, the threat given by PW, this appellant to PW 4, my lord, and in that respect, my lord, I would like to submit, my lord, one judgment, my lord. 704. It is 2013 5 SCC 705, my lord, paragraph 23. I have given the list. my lord. Para 23, my lord.
Para 23.
My lord. May I read, my lord?
Hmm.
In the case wherein PW9 was given a threat when her mother was forcibly taken away, but she had the courage to walk in the night to her grandmother, who was in her mid-50s. After coming to know about the incident, it defies common sense that the mother would not tell her other daughter and son-in-law about the kidnapping of the deceased by her mother-in-law. It is interesting to note that High Court has ascribed the reason that PW4 possibly wanted to save the reputation of the deceased daughter, and that is why she did not inform the other daughter and son-in-law. That apart, the fear factor has also been taken into consideration. Definitely, there would have been fear because, as alleged, the mother-in-law had forcibly taken away the deceased, but it is totally contrary to normal behavior that she would have maintained a snake-like silence and not inform others. It is also worthy to note that she did not tell it to anyone for almost 2 days, and it has not been explained why she had thought it apt to search for her daughter without even informing everyone else in the family or in the village, or without going to the police station. In view of the obtaining fact of situation, in our considered opinion, the learned trial judge was absolutely justified in treating the conduct of the said witness as unnatural, and therefore felt that it was unsafe to convict the accused persons on the basis of their testimony. It was a plausible view, and there were no compelling circumstances requiring a reversal of the judgment of acquittal. Two, it is the powers of appellate court in an appeal against acquittal are extensive, preliminary in nature, and to review the considered evidence, interfere with the acquittal, but the court should find an absolute assurance of the guilt on the basis of evidence on record, and not that it can be taken care of more possible or different view. Well, here, my lord, possibly the fear factor. Once, my lord, the FIR was lost, that fear factor vanishes from PW4. That you will kindly appreciate that thing, my lord. Once this FIR was lost by PW2, that fear factor goes immediately, my lord, because his statement was recorded under section 161 on 29, my lord, and it was recorded under 164 on the very next day, my lord. So
No, how will it go? Why? Lodging of affair does not bring in the PW4 into picture.
no, understood, ma'am. Because after lodging of the FIR also, it was lodged on possibly 24, my lord. This FIR was lodged on 27/6/2015. So immediately on
That is 22 days after the disappearance of the
my
body.
lord, my lord. No, my lord, that
Fear is gone, and that is how he comes forward and
My lord.
records his treatment.
my lord,
You're right.
my lord.
But then how does it help
My
the
lord,
appellant?
my lord, fear is such a thing, my lord. If I decide that I am afraid of somebody, I would not have approached the police and give my statement under 161. Had there been real fear factor, my lord. So far as PW from the appellant is concerned, my lord, he could have, my lord, exercised other sources in informing the police that this sort of incident has taken place in our village. And it is a village, my lord, not that city, my lord, everybody is busy. He could have exercised or outsourced other sources, my lord, in informing the police and not waited for 20 to 22 days in informing my lord or coming up with his story, my lord. That is my humble submission, my lord. And regarding that fear, my lord, the unnatural conduct, my lord, lordship will kindly appreciate, my lord, one thing. This is my lord 2008-17 SCC, my lord. Case 68, my lord. Could be para 11, my lord. Para 11, my lord. Thus, in the following circumstances, especially taking note of the unnatural manner in which PW7 kept quiet till 1.5 months after the incident, that too in the midst of thickly populated vicinity, it is not safe to convict an accused solely.
There are
relying-
11 of which judgment?
My lord,
What is the title?
my lord, 2008-17 SCC, my lord. State of Punjab versus Rajinder Singh. My lord.
In the SCC, there is no para 11.
My lord, it would be last paragraph, my lord. Last but the one, my lord. Last but the one.
Yes.
Thus, in the foregoing circumstances, my lord has found it, my lord.
State of Punjab versus Rajinder Singh.
My lord. Thus, in the foregoing circumstances, especially taking note of the unnatural manner in which PW7 kept quiet till 1.5 months after the incident, that too in the midst of thickly populated vicinity, it is not safe to convict an accused solely relying on her evidence. Thus, we find. Yes, judgment I am reading here. 2008, my lord.
This is not SCC, is it? Edward Yoxon? Point of code.
My lord, sorry, my lord, I am reading. Sorry, sorry. Para 18, my lord, I am sorry. 18. Sorry, my lord. 18-9, my lord. The High Court has noted that Leela Singh PW10 was allegedly the solitary witness to prove the charge. The High Court noted that he had not offered any basis for his presence in the alleged occurrence. Additionally, he did not disclose about the incident for about 10 days. And suddenly, according to him, his conscience pricked him and he came forward to speak about the incident to the police. It further appears that the manner of assault was specifically detailed is too hard to be believed. The High Court found that his conduct was most unusual, though he claimed that he was an independent witness and had no relationship with the deceased or his family members. The witness fairly admitted that he was closely related to the deceased. The High Court, in the aforesaid background, analyzed his evidence with care and caution. It was noted that his silence was most unusual because he was closely related to the deceased. Furthermore, the explanation offered that suddenly he became conscious of his constitutional duties to see that guilty persons get punished was hardly believable. His evidence about the manner of assault attributed to various accused persons was too hollow to have any credence. It was quite unnatural that the manner in which the assaults were given could be given with such precision when the accused persons were many, as was the number of injuries. That being the position, we did not find any scope for interference in the appeals with the order of acquittal so far as the offences relatable to section 302 or section 302-149 IPC are concerned. The appeal is noted above survives only in respect of respondent Rajinder Singh and Kulvinder Singh and Gurusaran Singh. The appeals are dismissed accordingly.
How long?
My
will it take?
last judgment, last. Well, this is AIR 2002 SC. AIR 2002 SC 2807. Toran Singh versus MP. Then my lord will come to para 17, my lord. Para 7.
There are 7 or
My
70?
7. The substantial portion of judgment. The substantial portion of the judgment of the trial court is contained in the narration of prosecution story and referring to the prosecution witnesses. We hardly find evaluation, analysis, or scrutiny of evidence in a proper perspective objectively. With regard to serious infirmities pointed out by the defense raising doubt of the prosecution case, the learned session judge has simply stated that he did not agree with such contentions. The trial court, in our view, was not right and justified in lightly brushing aside the infirmities and improbabilities brought out from the prosecution case. That too, when the entire prosecution case rested on sole eyewitness, who was interested being the son of deceased, more so in absence of any corroboration of evidence by any other independent evidence on material aspects of the prosecution case. It is unfortunate that the High Court has simply endorsed the conviction and sentence passed by the trial court without objectively and satisfactorily scrutinizing and examining the evidence as a first court of appeal, accepting narrating the prosecution case and referring briefly to the evidence of few prosecution witnesses. The reason recorded by the High Court is to be seen in para 10 of the judgment, which reads, thus, in absence of plausible defense by the appellant, and the fact that the deceased has stayed in the house of appellant and in the absence of explanation so as to cause of death, the appellant is liable to be convicted. The position of PW1 so and so inspires confidence and finds support from the medical evidence. In the light of what we have stated above, we find it difficult to agree with the High Court as to how deposition of PW1 Puran Singh inspires confidence. As is evident from the above para, the High Court, instead of giving benefit of doubt to appellant, placed on burden of defense and found that there was absence of plausible defense and explanation by the appellant. The case of the prosecution should rest on its strength, not on the absence of explanation or plausible defense by the accused. Thus, we find it difficult to sustain the impugned judgment. In the result, impugned judgment, affirming the judgment of trial court is set aside, the appellant is acquitted. This is my humble submission. And another thing, my lord, in 313, if lordship, my lord raises it, there was no question that whether you will evidence or do you have anything to say, anything, nothing like that, my lord. Page 30, my lord. For a moment, my lord. I just pointed it out, my lord. Page 30, question number 21, that is the last question, my lord.
So do you want to adduce evidence?
My lord, as an amicus curiae, my lord, I don't have any contest with my client.
You are amicus?
My lord. That is my submission, my lord.
Lordship. Here in this case, your lordship, a 10-year-old girl went missing for 22 days, no information. She was in the custody of the accused person, your lordship. PW4, who happens to be the eyewitness to the circumstances, your lordship, not as to the killing, your lordship, assault part, but as to the circumstances. Lordship, PW4 has been consistent all along. I have checked the 161 statement. In 164, as well as substantive evidence, he is consistent all along, and there is nothing to disbelieve in, my lord. And my learned friend has taken the plea that he remained mum for so many days. The reason is that, your lordship, the accused person is a loose character person. He used to be threatening to the people, and there's previous antecedent, previous cases also there regarding murder, your lordship. And he gave threatening to the village people, your lordship. And one of the factors we lordship will keep into account, at the time of the incident, this PW4 was only 17 years old. The natural instinct that he will have fear, your lordship. Should I read 161 statement of PW4, Your Lordship? Kishore Mall. মোৰ নাম ঠিকনা ওপৰত দিয়া মতে সত্য মোৰ বয়স অনুমান 20 বছৰ মান মোৰ ঘৰ আৰু দেৱজিতৰ ঘৰ ওচৰা উচৰি দেৱজিত পানিকাৰ ঘৰত এজনী 10 বছৰীয়া ছোৱালী থাকে নাম শ্ৰীমতী সৰু খাৰিয়া বহুদিন আগৰে পৰা দেৱজিতৰ ঘৰত আছিল আজিৰ পৰা প্ৰায় 22-23 দিন মান আগতে দেৱজিতে এদিন আমাৰ ঘৰলৈ গৈছিল সময় সন্ধিয়া 6:30 মান বাজিছিল সি মোক গৈ কয় যে তাৰ ঘৰত থকা ছোৱালীজনী জ্বলি মৰে সেয়ে তাৰ লগত যাব লাগে আৰু ছোৱালীজনীৰ ডেড বডি মৃতদেহটো নদীত পেলাই দিব লাগে মই নাযাও বুলি কোৱাত সি মোক ধমকি দিয়ে আৰু কয় যে নগলে মাৰি পেলাব দেৱজিতে আগতেও মোৰ দদাইদেউক মৰিয়াই হত্যা কৰি বহুত দিন জেলত আছিল ফলত ভয়তে মই তাৰ লগত যাওঁ তাৰ ঘৰত গৈ ঘৰৰ পিছফালে এজোপা টকৌ গছৰ তলত এটা টোপোলা দেখুৱাই আৰু কয় যে ছোৱালীজনী টোপোলাটোতে আছে সি তাৰ ঘৰৰ পৰা এটা বগা ৰঙৰ ডাঙৰ বেগ আনে মোক কয় সি টোপোলাটো বেগত ভৰাব কোৱাত মই ভৰাই দিওঁ তাৰ পিছত সি তাৰ চাইকেলখন আনে আৰু বেগটো চাইকেলত বান্ধি দিয়ে মোক ধমকি দি চাইকেলখন ঠেলি দিব কোৱাত মই ঠেলি দিওঁ আৰু সি মোৰ পাছে পাছে যায় তেতিয়া অলপ বৰষুণ দি আছিল কোনটো ৰাস্তাৰে যাব লাগে সি মোক কৈ গৈছিল সেইমতে মই তাৰ ভয়তে আছিলো কিছু দূৰ যোৱাৰ পিছত এখন পকা দলঙৰ ওচৰত চাইকেলখন ৰখাবলৈ কয় তেতিয়া সি চাইকেলখনৰ পৰা বেগটো খুলি দলঙৰ ওপৰৰ পৰা নদীত বেগটো পেলাই দিয়ে লগে লগে দুয়ো ঘৰত গুচি আহো দেৱজিতে মোক এই কথা কবলৈ মানা কৰে নহলে মোক মাৰি পেলাব বুলি কয় দেৱজিতক আমাৰ বস্তিৰ সকলো মানুহে ভয় কৰে আৰু তাৰ ঘৰত মানুহ নাযায় কাৰণ সি মোৰ দাদাইদেউক মাৰ্ডাৰ কৰিছিল কেইমাহমান আগতে তাৰ ঘৈণীয়েকে দৰৱ খাই মৰে মই তাৰ ভয়ত ঘটনাটো কাকো কোৱা নাছিলো এই মোৰ ক'ব লগা So this is the 161 statement. Now your lordship will come to his 164 statement at page 51. My name, address, and so and so. At about 6 p.m. on Wednesday, Devojit Panika came to our house and asked me to go to his house with him. He said that this is Soru Korea died by burning herself, and he asked my company to dispose of the dead body. When I denied, the accused threatened to kill me, showing a dagger. Being afraid, I went with the accused. On reaching the house of the accused, I saw that the dead body was kept at the backyard of the house. I saw that the dead body was kept inside a sack. The accused said that first he put the body in a net bag used for keeping tea leaves and thereafter in the sack. The accused brought the dead body from the backyard of the house and tied it on bicycle. And he asked me to accompany him to dispose of the dead body in Teok River. Being afraid, I accompanied the accused to Teok Bridge. The accused threw the dead body into the river from the bridge. After that, the accused and I left the place. The accused came to our house and slept there that night. And on that next day, also he stayed in our house. Police interrogated me. I have only this much to say. Now, in substantive evidence also he is consistent, Your Lordship.
Yeah, that's what we said.
Yes.
If we find PW4
Reliable. then-
trustworthy, the
Yes.
conviction will be upheld.
Yes. Correct.
Mr.
Yes.
Hmm.
Regarding
That's all.
corpus delicti, Your Lordship, recovery of dead body always not
Where
material.
is the
If
judgment? Have you got this?
I have got one.
Judgment মানে the Jalaluddin মানে the copy I have made.
If you have a copy, give it, or Mr. Andrew Dasna,
Right.
counsel for the appellant, we have also learned amicus curiae appearing for the appellant. We have also heard Ms. B. here learned application representing the state. Arguments concluded, judgment reserved.
I'm online. I'm only one copy madam that I have.
All right, then, it would report as a judgment is also. Has this been reported? I think it has been. Otherwise, return copy at a. Put a copy. Okay, all right,
Mine,
so we have a different DB.
Yes.
That's in the second half.
mine.
Yes.
God bless.
another court in a part method. So his part may be allowed to do on the next date. In the meantime, the appellant side may be heard.
It is that matter where discharge,
Yes.
discharge.
In fact, Lordship has extensively heard the other side. I started, then immediately Lordship shifted the burden to them to place their case. So they have completely placed their case. Now Lordship wants to hear what is our basic case to make out a case, not of discharge, but for trial. So those evidences Lordship would like to see.
That's correct, but it was heard some 2 months, 3 months.
Yes,
back.
that is why I'd like to place it. I won't. I'll try to satisfy this court by placing the facts in a chronological order.
That is true, Mr. Saikia. We would also like to finish it as early
Yes,
as
Lordship.
possible. Only difficulty is, we know you have your own pressing needs. These matters, if it is heard and finished off, then it helps us write
In
out a
fact, it
judgment.
was in that order on first and second, it would have been heard day-to-day basis. If Lordship hears today and tomorrow, I think it will be over.
There is no division bench tomorrow. The problem is we are in a zone where there is probably no division. This bench is not in division bench next week, entire week. That is the problem. But otherwise, yes, you are right. We agree that these are cases. What happens is if you hear it in piecemeal manner,
Lordship, even we forget, and definitely the other side also.
then piecing up things together takes a lot of time.
Lordship.
Not only for you, time is a factor for even for.
Lordship.
That's why I was wondering whether we can, even if we start today, we will not be able to conclude.
Absolutely, Lordship.
What would be a practical way, Mr. Saikia? While we fully appreciate
Lordship.
that you also need to go through and finish it, they also need to have an answer.
Lordship.
So these are matters which should be thrashed out.
Absolutely.
I think about half a day should be good enough for this. 1/2.
Yes, Lordship.
Will it be a good idea to start today or just agree on a date, half a day at 2 p.m. and just only
If
this
it
matter?
starts at 10:30, Lordship, then I think in the same day it will be over.
10:30 will be over.
Yes, Lordship. I have concised my
All
parts,
right.
which are
All right.
very relevant. That only I
All
will
right.
quote.
Facts, not much, because these are on the legal issue. Your argument basically was that the trial court could not have come to that conclusion at this stage
At this stage.
to hold that
There is
so
no
much of
material.
materials
Yes.
is not good enough for him to for framing of charge.
Lordship.
That is the basic argument.
That is the basic. And on top of that, the same court found lot of materials. The division bench of this honorable court found lot of materials, as well as the honorable Supreme Court. So the same judge at one point of time found sufficient material to make out a prima facie case and rejected their bail. They went before this honorable court, the division bench very categorically elaborated the facts and said that this is a perfect case for trial, although it was at the stage of bail. Then they went to Supreme Court, and Supreme Court also found sufficient materials not to give any relief. And the same judge overturned his own view.
Do you have the roster for January? You don't have it.
Not yet.
So, Mr. Saikia, frankly, would it be a good idea to agree on a date and thrash it out?
Yes,
one
Lordship.
day? No
3rd,
adjournment.
4th and 5th January. Lordship.
3rd, 4th, and 5th. You mean any day, any day?
No. Let it start on 3rd, because it
On
may
day by
spill
day.
over to 4th also. I will not take much. I will concise my arguments.
Will you prepare a written?
I'll
synopsis?
give along with my submission immediately. I'll hand it
You
over.
also give a written synopsis.
Lordship.
Yes.
Because otherwise it is on a small campus. Only thing is the court has to satisfy itself that
Yes.
these materials are not the right materials to come to this conclusion, or these are the right materials to come to. Therefore, we have to go through the materials. That is
Lordship.
why the time. And we have it on
That is
3rd.
precisely my parole today, that I have to point out and indicate which are the materials and relevant portion of the evidences.
Between 3rd and 5th, choose, or
Let it be on third, Lordship.
Third, you are available.
We'll start on third.
All right, then you take down, heard Mr. B. Saikel and his senior counsel, assisted by Mr. L. Satyanarayana, National counsel appearing for the appellant in both these appeals. We have also heard Mr.
D. Bora.
D. Bora, learned counsel appearing for the respondents who submits that the engaged senior counsel is unavailable at this moment and therefore the appeals be heard on some other day. The appellant's counsel has expressed urgency in the matter. Also, be that as it may, considering the fact that hearing of this appeal would require some time, we direct the registry to list these cases again on 3rd January 2023 as fixed part-heard matter. These appeals will be listed at the top of the list and shall be heard on day-to-day basis.
Highly obliged.
Obliged, Lordship.